Good evening. Welcome in Daily UPSC editorial audio program. Quid pro many quos. Times of India. Dem dem machine. Keep it clean and running. The Economic Times. Tepid trade offs. The Hindu. Now the full editorial. Quid pro many quos. The Times of India. A strange Supreme Court judgment on bribing MPs, MLAs finally get overturned, but not all bribes are provable. A seven-judge Supreme Court Constitution bench yesterday overturned a strange judgment delivered 26 years ago in 1998. A verdict in P.V. Narasimha Rao versus State concluded that legislators accepting bribes to influence their performance in the House was protected by the Constitution's article on parliamentary privilege. This interpretation triggered discomfort among subsequent benches. Finally, Supreme Court has ruled that the Constitution doesn't give a free pass to bribery. Upside down, the 1998 judgment defied common sense. It said if a legislature accepted a bribe and acted according to its influence, immunity kicked in. However, if the legislature agreed to accept a bribe but eventually acted independently, it would trigger prosecution. Little wonder many Supreme Court benches tried to tiptoe their way around this precedent, setting it straight how here onward bribery will be treated as just that. There are no privileges granted by the Constitution to protect legislators who accept bribes. This is the highlight of Supreme Court's judgment. It is clear and there are no loopholes. Supreme Court said that offense of bribery is complete when the legislator accept one that step is taken. There are no privileges that can be invoked to escape prosecution. Parliamentary privileges. The Constitution offers both MPs and MLAs a special privilege to express themselves in the House. This freedom of expression is unrelated to a citizen's fundamental right to expression. The purpose of parliamentary privilege is to enable elected representatives to carry out their functions effectively. Two-step test. Supreme Court also laid out a two-step test to draw boundaries around parliamentary privileges claimed by individuals. One, it is to be linked to the collective functioning of the House. Two, it must have a functional relationship to the discharge of duties. Elastic consents. On these points, there can be no disagreement. However, neither can the issue of bribery be viewed in black and white. Supreme Court said that when MLAs vote to select Rajya Sabha members, they require protection to ensure its exercise freely and without fear of legal prosecution. On paper, that's fine, but Rajya Sabha elections are infamous for votes. India's track record suggests conscience vote usually involve quid pro quo. But the quo is never something probable in courts. It just goes to show how fuzzy the subject is. In principle, she did the right thing. Reality is another matter, but law needs to be based on principles. Damn machine, keep it clean and running. The Economic Times aligning law with decency, political hygiene. What is surprising is not that on Monday a seven-judge constitutional bench of Supreme Court unanimously held that MPs and MLAs can't claim immunity from prosecution for accepting bribes to cast vote or make speeches in the houses in the house. What is surprising is that this was not the case to begin with, overturning its own 1998 judgment in the JMM case for votes case, in which MPs and MLAs were held immune for prosecution in bribery cases by dint of Articles 105(2) and 194(2) respectively. Monday's correction is most welcome, stating that taking a bribe is destructive of the aspirations and deliberative ideals of the Constitution, and that it creates a uh, polity that deprives citizens of the responsive, and representative democracy. The court has aligned law to decency and common sense, Accepting a bribe is an offense under the Prevention of Corruption Act of 1988. The action is complete the moment illegal gratification is done, and it is immaterial whether the legislator follows up with action, votes, or speech. Legislative immunity granted to MPs and MLAs was not a shield to commit crimes but protection to allow them to act without fear or favor. When such protection becomes an offensive tool, one has to reread the law aloud, which the court has. In a similar context of governance hygiene, the PM addresses cabinet and central government secretaries on Sunday, telling them that the general election don't signal a hiatus in governance. In other words, government must continue without a hitch, irrespective of governments. The Supreme Court ruling and PM's observation emphasizes a crucial principle that lawmakers in a democratic society must always keep in mind: the paramount obligation of elected representative to safeguard democracy's integrity by earnestly and transparency serving public interest, prioritizing public welfare over personal interest or political calculations, cleaning up the country's political system and keeping it clean deepens our trust in governance, the very CPU of any democracy machine. Tepid trade-offs. The Hindu World Trade Organization continue to struggle to foster free and fair trade. The latest meeting of WTO World Trade Organization's apex decision-making body concluded late on Friday, with precious little progress on key issues that affect global trade, despite extending deliberations by a day. To be clear, hopes for any significant outcomes from the 13th Ministerial Conferences MC13 in Abu Dhabi were not high to begin with, yet this was an important moment for the WTO to deliver on its mandate amid an increasingly fractious environment for the very rules of trade it seeks to enforce. The intervening period was delivered significant shock to the global trading architecture, such as the ripple effect of conflict in some parts of the world, the disruptions of critical shipment routes that are expected to linger for long, and recalibrations in supply chains to reduce dependence on single suppliers such as China. An increasing inward-looking tendency among nations has also catalyzed isolationist tariff heavy trade policies that run adrift of the WTO's primary purpose of open trade for the benefit of all. The Abu Dhabi Declaration does refer to some of the challenges, such as the need to ensure open, inclusive, and resilient supply chains, but there is little of substance beyond lip service. Divergences between the WTO's 164 member countries persisted on the most issues carried forward from Geneva MC12, including areas of particular interest to India, such as a permanent solution in agriculture for public stock holding to ensure domestic food security, or subsidies to the fisheries sector. The WTO Director General Ngozi Okonjo uh, Luala Luela has noted that the agriculture deliberations in the works for over 2 decades now have made some progress, as there is finally a text to work with that the body will strive to clinch in future parleys. The exemption for customs duties for e-commerce that India has sought an end to, citing the adverse impact of countries' revenues, will now carry on for at least 2 more years. Commerce Minister Piyush Goyal has nuanced this outcome, stating that India is not necessarily fully opposed to them. Prospects for the uh, res- uh, resuscitation of WTO's dispute resolution body rendered defunct for 4 years, remain bleak through though the Geneva commitment to revive the vital body by 2024 was reiterated. A key win for India at the MC13 was its successful effort with South Africa to part an attempt that was led by China and backed by over 120 countries to introduce an investment facilitation pact into the WTO framework. Going forward, India will have to redouble efforts to retain policy space for sensitive sectors, especially farms. The WTO itself must do much more to stay relevant in an increasingly polarized world. The member find it convenient to tout its failed biennial meetings as successes is a sad commentary on its winning efficacy. Thank you.